As we start this here, today is March 1st. We just came off of a weekend of the Oscars, right? So we felt it would be quite fun, actually, to kind of create our webinar here today around the Academy Awards, around an award show, all right? And so our feature presentation is focused on these top 5 failures, but as most award shows go, they start out by handing out awards, right? So we are going to actually do that here out of the gate. We've got a couple awards that we want to showcase here right out of the gate. There's been several nominations that have occurred, but I want you to think about some things. You know, when you think about ERISA, and I'm just making sure my PowerPoint is moving here. There we go. Sorry about that. So when we think about, you know, the first award that we thought we would actually share was the award for the best director. And when you think about ERISA, when you think about, okay, who's in charge, who is directing traffic, who is creating the rules of the road, the obligations, the requirements, the steps, the processes, the language, who is actually doing that? Well, you've got to have a director. They got to be good, all right? And so the first award that we're going to hand out, and folks, we're going to have fun with this. Unlike the final mistake of the night from the Oscars, we have double-checked, triple-checked, quadruple-checked the winners of each of these awards, so we don't have an embarrassing situation on our hands by the end of our webinar here today. So the award for Best Director goes to the Employee Benefit Security Administration. You know, you guys got to know who are the ones under the Department of Labor who are actually directing traffic here, directing the rules, the obligations, these requirements. The EBS, as we go by EBSA, but the Employee Benefit Security Administration is just that. They provide guidance, education, content. They do a lot of public forums asking for information and comments about specifically about their specific requirements. So the award for Best Director goes to EBSA, the Employee Benefit Security Administration. Our next award, though, actually goes to the award for Best Foreign Language Film. Steve, where are you going with this? Well, we feel that I think most employers, when they begin to look at the compliance requirements of ERISA, they're scratching their heads, right? But we were thinking, well, let's take this a little bit further. If we were going to award someone for the best foreign language film, who could that be? Well, the winner of the best foreign language film category is the Department of Labor agent during an audit. Yes, they are speaking a different language many times to each employer as they're going through the audit process. We feel, though, that employers can be adequately prepared ahead of time, and as we begin to go through some of these failures, we're going to provide some great practical application to that. So a little in jest, but the award for the best foreign language film is the Department of Labor agent during an audit. All right. Now, I always struggle a little bit with kind of hitting hard with some of the penalties and the exposures and things like that that are going on, things that are ending in monetary results, right? But what I do want to reflect here is that you do need to understand the activity that EBSA is having in the enforcement action category. Okay, very important that you recognize this. Now, EBSA's oversight authority extends to nearly 681,000 retirement plans. Also, they approximately sit on or have oversight for 2.3 million health plans and a similar number of welfare benefit plans, such as, you know, your life and disability insurance, okay? So they have strong oversight, and when we just look at the enforcement actions, we notice here over the last 3 years that EBSA has recovered over, actually, by the end of fiscal year 2016, which these results came out, so these are fresh and new, but they had recovered $777 million in recovery in 2016 alone. And since 2014, they've seen a 30% increase in the monetary dollars, or plan assets that have been recovered over this time. So you can see just from this number, I mean, this is amazing. There's a tremendous amount of activity here that is going on from EBSA. Now, EBSA doesn't stop just there, right? There are civil investigations that are also going to occur. They closed over 2,000 civil investigations, with 67% of those resulting in monetary results. So very active in the investigation phase. But I also want you to know that EBSA does have actually a heart in it as well. They often pursue voluntary compliance. So in our discussion today, we're going to be talking about, a lot of these failures that occur can actually be easily averted with some simple practical application. But an employer who knows that they're not conforming, they should do due diligence and ensure that they're trying to fulfill that specific obligation. So EBSA often pursues voluntary compliance as a means to correct violations and restore losses, all right? And so what you see here is in the filing side for 5500 forms, they had created a Delinquent Filer Voluntary Compliance Program, or DFVCP. And they had received over 22,000 annual reports in fiscal year 2016. And so they encourage plan administrators to bring their plans into compliance, and to do so on that voluntary compliance basis. Okay, very important. As we'll kind of discuss a little bit today, we run into many situations where employers clearly needed to comply over the last year, 2 years, 3 years, 5 years. And it's always recommended that they voluntarily go through the filing, go through this delinquent filer program, and it will greatly enhance their ability from a financial aspect to not dish out as much in those monetary losses. All right, so the enforcement is real. Let's start talking about, though, some of these top 5 failures. What do we see as our organization, what we see out there today that employers are failing more commonly in these 5 areas, and really focused around these non-wrapped ERISA plans, all right? We then, in the spirit of our feature presentation here today, we're going to provide our nominations for the top 10 requirements of ERISA. Think of it like the short list, all right? This is going to be those top 10 items. It's not the all-encompassing items. There's a lot of items for ERISA compliance, but if your clients have succeeded in kind of ensuring that these top 10 are there, whew, you are well on your way to compliance. And then lastly, you might say, Steve, hey, is there a award for me? Am I nominated here? What about me? What about my agency? Let's kind of bring you into the loop here in regard to what that looks like. So in all of this ERISA discussion, where do you fit? Where's your role? And did you win an award? Let's see. So as we get started, I am excited to actually introduce our special guest, or should I say special guru for today. Ann Liebeskind is on our webinar here today. She is our Client Success Manager for our ERISA Compliance Services. Ann, we welcome you. Thank you for coming here today and sharing your insight.
Well, thank you, and welcome everybody, and I'm just very pleased that I've been nominated by the Academy to speak to you today in the spirit of this, but I'm excited to share some of these failures and the solutions to those failures with you.
All right. Fantastic. It is just an honor to be nominated, right, Ann?
That's exactly right.
Right. All right. Well, we are going to dig right into this, and for those in attendance here today, we talk about these failures, and then there's generally, right, this negative tone kind of to that. Ooh, you're failing in this area. But our ultimate goal here, as we list each one of these 5, is to provide some real, some solid, comprehensive, well, I should say, as comprehensive as we can here in the webinar, practical application as to how your employers can indeed sail through any of these issues so that they have complete success. So we're going to go ahead and dive here into our first one of the day, and our number 1 failure here that we are listing is the failure to file an individual filing for each benefit plan. Ann, you want to start digging into this?
Yeah, absolutely. So in the universe of plans, of the benefits offered by employers, without a wrap plan in place, each one of those plans, medical, dental, life, are all considered individual benefit plans. And as a result, in the absence of a wrap document, each one of them is responsible for filing a 5500 with its corresponding Schedule A from the carrier in the case of a fully insured plan. That if they have 100 enrolled employees, and that's, be very careful, that's not necessarily participants with dependents, but it's certainly 100 enrolled employees, or if they're not over 100, they have segregated assets in the form of a trust or a separate account. So many employers are not aware that it's not permissible under the reporting requirements of ERISA to lump all of their benefits together on one 5500 and say, great, it's done, I've put them all on there. Not permissible, because they're considered individual plans, each requiring a filing. So that is one, I've encountered this with several clients where they have done that, and that is certainly outside of the rules of the road. So what happens in that case is that under ERISA, if they were subject to an audit, it would be deemed incorrectly filed. And in addition, for perhaps any of the ones that were the component benefits were lumped under there, they would be considered delinquent. So they would not be considered filed at all, actually. And then what makes that worse is that as of August 1st, 2016, their penalties have increased for every single day that this is not filed properly. So how do we avert this failure? We file one 5500 for each separate plan, medical, dental, life, if they are over 100 enrolled employees. The other way to avoid this entirely is to put a wrap document into place. In the presence of a wrap document, you don't have to worry about filing one filing for each plan. You can file one 5500 with each of the component benefit plans. So that makes it much easier, much neater. You only have to keep track of one deadline for 5500, and that is really the best way to go about it. If you don't wish to have a wrap document, you need to make sure you file one for each plan.
And a question that did come in here, and it's kind of around those enforcement results, where it's saying here, you know, it would be determined that it was incorrectly filed, or technically it would be considered delinquent. Kind of a step then would be what I had just mentioned originally here with the EBSA, kind of the enforcement actions. We would encourage them to look at filing through that delinquent filer voluntary program. Is that what you would recommend?
Yes, I would recommend that. Basically, the best way to resolve that issue is to file under the delinquent filer program that caps your penalties at $10 per day as opposed to the much higher filing failure.
Very good. Very good. Thank you, Ann. All right. Well, we're going to go ahead and move to the next one, number 2. And it is, it's a little, it's somewhat, I mean, I feel like, okay, it's somewhat similar to what we had just mentioned, but it is a little different. It's tweaked here a little differently here in our question. And the second failure is the failure to file at all for any of the plans that that employer is offering. So, Ann, do you want to share a little bit about this?
Sure. So in addition to most clients not being aware that it's, you know, that they have to file for one for each plan, many employers aren't even aware they need to file one at all. This is that it should be filed annually, that it should be filed with a corresponding Schedule A. While small plans are generally exempt, they're not even aware that by the end of their 7 months after the end of their plan year that they must file that. They must file it. So we are, even though you can have an extension of 2.5 months by filing a 5558, but basically I have several clients who've called and said we've been in the process of doing a wrap, and they say, hi, okay, great. And I say, well, you're over 100. Have you filed your 5500? And many employers are not even aware of its existence. So what happens? If they have not filed in a timely fashion or filed at all, that penalty is $2,097 per day, per plan. that's a scary number. So in that case, there is a real urgency to finding how can we solve this problem, or how can we avoid to do that. And that's by making sure you're aware of when your filing is due and if you're responsible for filing under the rules. So once you do that, you look at your plan numbers at the beginning of the plan year. If you've just passed over that number, you would need to be aware that by 7 months after that, let's say you have a 12/31 plan year, you would need to file.
And do you, I look at that 2,097 number, and that seems to be like just a different number than I imagine, or it's much higher. Has there been a recent change?
There has been a recent change. It used to be lower than that, and back in August 1st, 2016, it was changed, and then another component was added into it where there is now a COLA increase every January 1st. So that was 2,063, it's now 2,097. So rather than paying $2,097 a day, my recommendation for failing to file would certainly be the DFVCP program, which is $10 a day.
Oh, that's much better. Okay. Oh, that's what I want to hear. So yeah, I think our recommendation, and yours, Ann, too, would be, be proactive. Don't just necessarily put your head in the ground. If you recognize, I should have been filing, potentially here. No. Be proactive. Utilize that delinquent filer voluntary compliance program, because that certainly will have the opportunity to cap really those potential penalties and fines, because if it moves into another field of enforcement, those penalties can be much, much larger than what you'd find through these voluntary programs. Let's see here. I'll look at questions just as a reminder here. I'll go ahead and go to the next failure. I've gotten a couple more questions. I will read those when Ann covers the next failure, but continue to go into the GoToMeeting menu bar, type in your question, and we will get those answered. So, Ann, we have failure number 3, and these failures, all of these are so commonplace. It just happens time and time again, but there are some simple remedies. But this failure number 3 is the failure to produce a plan document, and I know that seems like a lot of confusion kind of around, well, what is that plan document? So, Ann, why don't you shed some light here on this one?
Yes, so this is actually one of the most important failures that we encounter with clients and with employers, is that we're talking about non-wrapped plans here. It's a failure to have a plan document at all, and that which is something that will detail the plan provisions. And all employers except government entities and churches are required to have them, and it is a requirement under ERISA. So any group health plan or group qualified ERISA plan for 2 or more employees, medical, dental, vision, short-term disability that's an insured product, an FSA and an HRA, a plan document is required. And so many employers say, well, yes, I got that plan document from my carrier, and the carrier gave it to me. Not so fast. That is not a sufficient plan document. The plan document is really an employer-centered document. It is really the document which establishes the plan, which discloses under ERISA the eligibility provisions, who the fiduciary is, who the plan administrator is, how claims are handled, how termination of the plan will be handled. So this is really an essential document. And as we mentioned for the first failure, every single one of those component benefits is considered a separate plan in the absence of the wrap. So theoretically speaking, each one of them should have a plan document. Now, that would be a lot of benefits if you have a large company with 10 benefit options. Whereas if you have a wrap in place, you only need 1 plan document. So that is really, that is, ERISA states you must have something that establishes this plan, that sets forth these provisions of this plan and the rules for this plan, and then it must also be available to any participant who requests it. So in the absence of a plan document, upon a request from a participant, and within 30 days, if you haven't produced it, and the DOL comes and figures this out, there is a penalty of $147 per day for each day that the plan is out of compliance. Not something you want to be faced with. There are definitely cases that are out there that are where participants have not been provided the plan document, either through refusal or just a failure to have one, and it's had some serious consequences. So how do we avoid that? We create a plan document that has all of the necessary requirements under ERISA, and we officially adopt that. There is a question of, should I wrap or shouldn't I wrap? What does a wrap do for me? A wrap basically provides a very convenient way to address all of those provisions for all of those benefit plans.
And a non-wrap then would just be separate, so that's separating out each plan into their own separate document. Is that correct?
So the medical, yes, correct. So the medical plan would have its own document, and the dental plan would have its own document.
All right. Well, and this failure has provoked a lot of questions. So we've got a flurry of activity here right now. And I think as I look at a few of these questions, I think we can hit a few of them all at once. There seems to be a corresponding question about, well, I thought ERISA was for any size employer, not just those over 100. Can you explain maybe that difference, this 100 employer size versus non, and ERISA applies to all employers or just those over 100?
Sure. Let me explain that and backtrack that. If that was the message, I apologize. No, as we said, it was to 2 or more. If you look on the first rule of the road on this current slide, it says 2 or more employees for non-church or non-governmental entities. So in general, there's 2 parts under ERISA. There's the reporting requirement, which is a 5,500, and the disclosure requirement, which is the plan documents and the SPDs. So the disclosure requirements apply to all employers, absolutely, with employer-sponsored plan. For the disclosure, for the reporting, which is the 5,500s, those are, there were several different technical releases that went out over the years, but basically for the disclosure for 5,500s, the rules are if you have 100 or more enrolled employees in a benefit plan, or if you are under 100 employees, but you segregate the assets, you set them aside, the plan contributions in a separate account, or you've established a trust for your contributions, you're not exempt, so you must file. So there's some very technical, specific requirements for 5,500 that you need to look at your enrollment, how the plans are set up. So please, let me clarify it if I misspoke. The reporting for 5,500 has certain parameters. 100 or more is generally for fully insured plans, whereas for the disclosure, absolutely any size employer with a group health plan must have those documents.
Mm-hmm. Oh, very good. No, that actually, for a lot of the questions, or several questions, I think that should help clarify, so thank you, Anne. There was a question about voluntary benefits, yes, and just asking about what voluntary plans are exempt or non-exempt.
Sure. So voluntary plans are sort of, unfortunately that term gets used for a variety of scenarios. So the way that we like to talk about it is, and this is a subject of debate among ERISA gurus, but certainly a voluntary plan, if it's sponsored by the employer and the employer's considered the policyholder, so the policyholder listed is ABC Company, even if the employee can freely elect it and pays 100% of the premium, that's still considered a group voluntary plan. Whereas a voluntary plan where the employee is issued an individual certificate, an individual plan, and pays 100%, we call that worksite, more of a worksite plan. That is not considered a plan under ERISA. That is not considered an ERISA qualified plan. Just as a short-term disability plan that's a payroll practice isn't considered ERISA, or just as actually a health savings account because it's an individual account not held by the employer, it's not considered an ERISA plan. So we actually don't include HSAs in our wrap document.
Very good. Yes, that is very good.
So,
yeah, thank you. I think that is perfect. I'll do one more question here, and then we'll move on to our next failure number 4.
Sure.
The question came here from Jennifer. If someone has not filed a 5500 in the past, and it could be, number of years, right, that they could have qualified but did not, and then they start, can the past years be forgiven?
Ooh. Well, that is quite a question. I have had several clients come to us in the past year where they were not aware, as we talked about in failure number 2, they weren't even aware that they needed to file. And so they had been over 100 for several years. The typical DOL audit goes back 3 years. So generally speaking, the best practice is to employ the DSVCP program for the years that you can file for. Right now, we're still, the DOL has on their EFAS site has the ability to file as far back as 2013, and each year they take another year off. So basically right now we're 2013, 2014, 2015, 2016 are available. But you would have concerns about anything that was 2012, 2011 or before. So, and unfortunately, because it's only permitted to be done electronically, if you don't have that capability on the government website, you unfortunately have to roll the dice on the 2011 and 2012. There's no statutory limit on how far back they can go, but as I mentioned in the beginning, this is a 3-year typical audit. So the best bet would be to file as many years as possible under DSVCP and then stay current on your current plan you're filing.
Very good. Thank you. Guys, keep those questions coming. We will try not to, we're going to try to hit them all here. So we're just going to move on here to the next failure. Failure number 4 is also a biggie, a real biggie, because I think a lot of employers might feel they might have this in place already, but they may not. That's where that foreign language kind of comes in. So number 4 is the failure to create and distribute summary plan descriptions. Anne, lead us through this.
So this is the second part and the most important, this is not the most important, but it's the second prong of the very important disclosure regulations. So basically, summary plan descriptions, I like to describe them as the most participant-oriented aspect of ERISA. This is really the roadmap for participants to truly understand what benefits they are eligible for, how they are funded, how they are premiums are paid, how long do they have to wait for benefits, and then how claims are paid, and so many other very important participant-oriented matters. So essentially, the government requires the plan document, but also requires the summary plan description, and along with that requirement comes a timeline for distribution to participants. You must receive this within 90 days of being enrolled. You must receive it if you request it within 30 days. And then it must be distributed in a particular manner that is a method that can prove distribution. So there are several options. There's mailing, there's hand delivery, and there's electronic delivery. And then there's some things that plan sponsors and administrators should, steps they should undertake to be able to prove that they distribute that. So what happens if you don't? Once again, that $149 per day from the date of the failure comes into play. So for every day you fail to distribute this to participants, you will be fined if the DOL either audits or is notified that you were not provided with this document. So how do we avoid this? We create an SPD whether, again, for these non-wrap plans, if you're not under a wrap, you should have an SPD for each one of them. And under the, and so everyone, once again, we go back to, but hey, I'm an employer and Independence Blue Cross gave me this great certificate of coverage and it's really big and it's really thick and it's 100 pages. Surely this is adequate. Not necessarily. Again, this is something that we'll chat about in a bit, but basically you should have an SPD that is available and includes all of the necessary requirements of ERISA. You should also distribute it, usually at open enrollment every year, especially if you've made changes. You are required to make it up to date as much as possible, and it must be distributed when someone is newly hired, and it must be distributed generally anytime that there is a significant change to the plan.
Very good. Ann, we're going to hit some questions here again. There's some good ones. David talks about self-funded plans, and he's asking, since most self-funded plans have a plan document, an SPD, that's already provided potentially by that TPA, can you keep that as a standalone ERISA plan and then wrap their dental, vision, and other ancillary lines in a separate wrap?
You could do that. You can do that, certainly. There are some, we've done that before, where there's ancillary coverages and then medical. It depends on the sufficiency of the plan document, if it's provided by the TPA, if it meets all of the requirements under ERISA for all of the information that is required to be given to the participant. Certainly you could do that. It's very possible simply to wrap everything under one plan. There's really no need to split the fully insured and self-insured in an umbrella wrap and an umbrella SPD, because funding can be handled separately. As we do in our documents, we have separate sections that detail which are the self-funded and which are the fully insured, and it works out. It can work out nicely. But if that's a preference, certainly that can be done, but they must be adequate, both documents.
Okay, very good. A couple questions then centered around the enforcement, the penalty side. And Gary is asking, this $149 per day penalty, does that go to the participant asking for the plan documents, or is that a penalty that is paid into EBSA, into Department of Labor?
Sure. That is certainly not assessed against the participant. That is assessed against the plan sponsor, and that is then directed to EBSA, and it's a penalty under the statute, so they get that money. The only time you would really see any money out of litigation for a participant is if there was a civil action filed for a violation of ERISA. And then generally those are sort of set forth as to what those penalties would be. Okay. And that would really be, on a case-by-case basis.
Very good. Gary asks as well, just, do you think, what's your opinion in regard to the DOL enforcement today? Do you expect it to go down, go up, or stay the same under the new administration?
That is a really, that question has a lot of parameters. I will say that I think there's a huge focus on ACA right now, but I think as far as the auditing has been in place, ERISA has been in place since 1974. They recently hired, although there's a hiring freeze now under this administration, under the last one there was a significant increase in auditor hiring. And I do believe, even if there are significant changes to ACA and the auditing being done under that, I still believe that there will be an increase in auditing under the current administration, simply because some of those were already put in place ahead of time. Now, whether he changes that or not, or they, I should say, the administration changes that, I don't know. But I do believe that there have been some recent judgments handed down where there have been significant abuses of fiduciary responsibility with participant contributions, and I think that is something that the DOL and the administration will continue to do because it's very detrimental to participants.
Very good. You know, just kind of, I guess, staying in line here with this political theme and thinking about the new administration here that is now in place. The next failure number 5, is really centered around one of those key, I don't know, future variables of changes that certainly can occur, but it actually entered our top 5 failure list. And so, Anne, can you speak to this failure within ERISA to include Affordable Care Act provisions?
Yes. So what I mean by that is not so much, I mean, many of the carriers handle the more coverage-specific information, SBC information, but as far as in an SPD, what many employers don't realize is if you're an ALE, which is over 50 full-time employees or full-time equivalent employees, and there are variable hour or seasonal hour employees within that universe of your population, what many employers don't realize is those are actually considered eligibility provisions under ERISA. So any ACA measurement or stability periods or administrative periods, they tie in with your eligibility and your waiting periods, and those must be included. So when you get, and many carriers, and this is a theme, many carriers are moving to generic certificates, generic SPDs, and they're not including an employer-specific provision. They say that's up to the employer to enforce. Well, it's up to the employer also to disclose these to participants, and if it's not done in enrollment materials and if it's not done in an employee handbook and it's not made clear, it is really important that if there is a plan document in place that those provisions be detailed in one place for the employee to understand how they interact with the plan's provisions. And so understanding that they are considered eligibility provisions and they need to be disclosed. So what happens is that if in the event of an audit, they would want to see whether or not you've documented your eligibility, these ACA measurement periods, that you've made aware to those variable hour employees that, hey, you may not be full-time now, but if you are calculated to be, you might be next year, and this is how it would work and when you would be eligible for coverage. So they would correct, if you say no, they would want corrective actions, and there is potential liability on the employer's part if either they were not followed or they didn't make the employees aware, and an employee went back and found out and said, oh, I should have been eligible for coverage and you didn't provide it to me. They could obtain an attorney, they could notify the DOL. So it's very important that until such time as any legislation changes or takes place that these continue to be documented. I don't foresee, I'm not going to get into the ACA and its own in particular reporting, but I don't see, based on things that have come out in the new administration, any mention of changes being made to this variable hour eligibility. So at this time. So while we won't discuss individual mandate or any of those things here, I'm under ERISA, certainly there is a tie-in, and I don't see this going away immediately.
Okay. So, yeah, very important. It's very important that the variable hour employees receive the information on the eligibility. And just as a reminder, just a couple things here that I had written down additionally, so you really need to include all of the eligibility information, the waiting period provisions, the funding methods. When you think about just all of those group health plans, those plans that are being implemented or offered. But don't forget as well that you must list the health FSA and HRA eligibility and funding methods as well. I mean, those are important. Don't forget about those specific items. That health FSA and HRA are both considered a group health plan, and so you need to include that additional provision. This ACA piece is often overlooked, and that's why we've included it here in the top 5. It's very important that the employer provides a mechanism to communicate these provisions to those employees or to any of those eligible employees where they would be impacted. I want to go back to the questions, Ann, here. There's some really good ones.
Okay.
So let me see here. So the first one here is about small groups. Small group scenario, when there is a change in carrier and or plan design from one year to the next, does that require an amendment to the wrap plan document each time such carrier or plan change occurs?
It is, we recommend it. It is important with the carrier, it's important for them to know who the carrier is and where their benefits are coming from. I recommend amending the plan. I think it's really the eligibility provisions. You know, what's a material modification? Taking a benefit away, absolutely. You need to notify and you need to amend. If you are adding a benefit, absolutely, you need to amend. They need to, for any new hire, you know, maybe you've had several people and then you decide to add a vision plan in mid-year. Well, any new hire after that would need to have a document that accurately reflected the benefits that they were eligible for. So adding benefits, taking away benefits, while under certain circumstances is not mandated, I certainly am an advocate for being proactive and not waiting for the last minute to do that. So basically, even with small plans, I find that even 10 people, you know, 10-person plans may not even have a document in the first place or plan document in the first place, but certainly it's important to keep it updated with the relevant information.
Good. We'll just cover a couple more here, but really good ones. Victoria asked the question, if an employer has more than one class of employee, and she's describing it as relating to 2 classes with different eligibility criteria, would the best approach be to create 2 separate SPDs, say one for each class?
So what we have lots of clients with lots of complex plans, and one typically, as long as you don't have ownership issues under common control status, you can do one plan document. But it's really an employer preference. I will say that we have some employers who will want, for a variety of reasons, whether the premium situation is, you know, paid for one set and not paid for the other, or their shorter eligibility, they want to have those benefits separated by class, and in which case 2 SPDs, let's say hourly and salaried. Maybe salaried gets some long-term disability, but the hourly does not. And for whatever reason, they wish to keep those separate. Yes, you would do 2 separate SPDs. I have other clients who say everybody is very well aware of who gets what, and so it's no problem, and we will put sections in the SPD and the eligibility section. Class 1 gets, you know, medical, dental, life, and Class 2 gets medical, dental, life, STD, and LTD. So it's a preference. It just depends on how intricate the provisions are and what you know, what transparency that the employer wants to provide to the participants. In the end, they could request both of them, but you know, certainly it's just a preference for the most part.
Good, awesome. Thank you, Ann. We're going to go ahead. There's probably a couple more that we'll touch on, but Ann, we wanted to kind of get into our bonus round here a little bit. Okay. Here. So and we wanted to provide each of you kind of this quick short list, okay, of nominations that we have made to cover the 10 things ERISA requires. Now we could spend probably several hours talking about each and every one of these, I suppose. Well, Ann, you could. as our guru. But we do just want to briefly cover these because we feel that if these 10 things are there, man, your clients are well on their way here to compliance. So we're going to kind of quick shot these here, kind of go through these pretty quickly, but I'm going to ask Ann to kind of cover a couple of these, maybe in just a little more detail to provide some, overall color to what we're kind of asking here or telling. So the first 5 are these. We have, as Ann had mentioned, thinking about and talking about plan provisions, eligibility provisions, waiting periods, knowing that as far as who is eligible for these benefits, yes, you have an employee, but spouse, dependent, domestic partner eligibility, that information would need to be or is required as part of these documents. You also want to think about funding considerations and premiums and contributions. And then lastly, right, when you think about claims, ACA, HIPAA, we've got a lot of appeals procedures that will need to be included as part of the overall requirement. So Ann, I don't know if you want to take one of these and just bring it to life just a little bit more.
Sure. So as I've mentioned a few times throughout the webinar today, something that's really, really becoming apparent to us is in terms of cost savings for insurers, they are very much limiting the amount of customization they put in their SPDs and in their certificates of coverage, and they are becoming very, very generic and saying this is up to the employer because they're trying to save money by not customizing. So very, very important to put eligibility and waiting periods in your non-wrap documents or in a plan document for your non-wrap document, because as I've said, yes, you could hand out each individual document from the carrier, but if they don't have those eligibility provisions in there, they're not sufficient. And you would consider to not have a document at all, an SPD at all, and you would be fined. So as an employer, so certainly those are the major, very important things that I would say that you must have in a wrap document or in a even in a plan document in an SPD for a non-wrap document. So domestic partner eligibility is also up there. We have, after DOMA was overturned, we have, those are basically spouse, so that's not an issue. But those are some very important things to consider, is that, especially these days, about eligibility.
Very good. Rounding out this top 10 are these 5. We did speak about number 6, ACA measurement periods, the importance of ensuring that these provisions are within the document. So it's stating that eligibility and their ability to have or to not have coverage based on their performance kind of through that measurement period. Also, you can never leave out, right, Cobra aspects, certainly where they apply, that Cobra is still near and dear, and that language is very important to be placed within the documentation. Leaves of absence, very important. As you get into the 50-plus environment, you might enter into some Family Medical Leave Act types of requirements and language that's going to be in there as well. Number 9 is key notices, and I think maybe for many that are on the webinar here today, you might think to some degree that all of these notices are covered, maybe potentially by the carrier, or in some other fashion, maybe a TPA that's involved, but that's not always the case. And so you really need to consider key notices like the Women's Health Care Rights Act, the WICRA notice, certainly ACA notices, Michelle's Law, GINA, CHIPRA, USERRA, all of these are provisions that could be language included within the document or provided as a separate notice. And then lastly, just overall plan administration. This is very consistent with other documentations under Section 125 and under Section 105 as far as the overall plan administration. So Ann, I don't know if is there one thing here that catches your eye that you want to dive a little deeper into?
I think that the best, we spoke about the ACA measurement periods and Cobra, of course, but I believe that the most important is these WICRA, the PPACA, GINA, CHIPRA, USERRA. Many carriers don't put that language unless it specifically applies to the type of benefit being offered, but these are all key things that need to be addressed, need to be in there that would not necessarily be there. But to protect employers, which is really our goal and my goal as I do documents and 5500s every day. It's very important that there's so many things, so it's best to have it all in there so you're not caught unaware. And then for plan administration, that is such a broad term, but so much about how are claims handled, how, HIPAA disclosures, who's the plan administrator, who's the service, agent for service of process. Those are all required elements under the law. And so certainly, who can the participant go to if there's a question about the plan? That is an absolute necessity. And I think that that just needs to be spelled out, and employers need to be aware of it.
One of the questions, which is probably pretty good, it ties into a previous question that we were unable to get to, but it's kind of like a number 9 here, key notices. Is there a place to go to get information, on those notices? And one of the questions even stated, is there a model notice, or are there model plan documents that can be utilized? Any comments on that?
Sure, yeah, absolutely. EBSA, if you go to EBSA, it's, I believe it's dol.gov//EBSA, has model notices. We had a client who wasn't even aware of Cobra, didn't have a Cobra administrator, and said, where can I go? I have somebody that left yesterday and I don't know what to do, and in that case, certainly I can point you out to that, but there are, CHIPRA that notice is available. It is updated. That is on the website. Model notices are available through the DOL. It's very easily found in a Google search, to be honest, but making sure that you know it applies to you is crucial. Making sure, some of those are dependent on size. For Cobra, FMLA, some of the WICRA, of course, WICRA and the other ones do apply, PPACA. There are some provisions that do apply to small employers and some that do not. So certainly, while all of those model notices are available, what is nice to have them all in one place in a document so that you never have to worry about that. There is also Medicare Part D is very important. Those are more geared, for employers to customize on their own because it requires personal information, protected health information, or protected information about participants. But those notices are available on the website, but highly recommend that employers acquaint themselves, or brokers acquaint themselves before someone goes out and uses them. So.
Very good, and that's just great information. I'm sorry that we just can't get to everybody's questions here today, although as I cover just a couple more things here with you today, because we still have a couple awards to hand out, maybe Ann might be able to get in and personally answer some of your questions here just as I wrap some things up. PrimePay wants to try to simplify at least what you're doing as an agency and driving overall value-added solutions to your clients. And providing this information as we do today has been something that you guys have actually told us in a survey. You said, listen, we need access to compliance, we need technical resources, we need education, maybe not even to us as an agency, but to our clients. And so I did want to mention here in regard to our Broker Concierge Partner Program, and I mentioned our purpose before of our program, it's really centered around 4 things: strengthening client relationships, neutralizing competitive threats, meeting the various and just more prominent client demands that they're coming to you with each and every day. But it's also about growing your business as well, creating new revenue streams. And so you might be sitting here going, okay, Steve, I don't know if I'm ready as an agency to sit there and start communicating ERISA, driving ERISA, information and content. I don't know if I'm ready, but I want you to think about, or I guess what I want to stress is that Broker Concierge, our partner program, can really enable your agency and enhance it to really drive ERISA ultimately to your clients. And the way that we see it, based on our purpose, is really done here in 3 ways. I think in talking about ERISA, setting ERISA on the table, not hiding it, but getting it out in front, will absolutely enable your agency or enable your clients to depend more on your agency. And clearly through that is absolutely going to lead to a stronger client relationship at the end of the day. But it doesn't stop there, right? Because your clients are asking you these questions. It's possible that the questions that you ask today are actually those that you've received from your clients. And so by talking about ERISA, partnering through Broker Concierge, we can actually allow you or enable you to meet real substantial demands from your clients, because it's not going away from them, and Broker Concierge can drive real information and resources to you to enable that, to fulfill that demand from your clients. And what we also think that ERISA, this discussion can ultimately do as well, is actually open many new doors for you in regard to new opportunities and certainly create new revenue streams. I mean, most of you are centered around health and welfare benefits, right, and ancillary services. The ERISA piece, the compliance piece, is not, hey, maybe you should have that. No, actually, an ERISA plan should be paired with every health and welfare plan that your employers are offering to their employees. So consider, if you're not a partner today in their Broker Concierge, we have the resources and tools to enhance your agency's product suite of services and through ERISA. Several of the questions that I've received have said, oh, I have additional questions. Who can I touch base with? We want you to reach out to Broker Concierge. Allow us to facilitate and drive connections to get you the answers that you need. So, our last, we got a couple of awards here, last awards that we need to actually hand out. And this one actually, although many were nominated, this was a no-brainer, okay? The award for the best actor and actress in a leading role is you, the benefits broker. Because if you take this information, not hide from it, not kind of get scared away from it, but actually adopt ERISA as a main communication solution for your agency, you are absolutely sitting in a leading role to allow and permit your employers to actually avert all of these failures that we spoke about today. The next award is for Best Original and Screenplay in Writing. So over the last couple of months, I would be remiss to say that probably one of our best service and quality teams here at PrimePay is our ERISA team. So partnering with our Broker Concierge service and team, coordinating that through our ERISA solution, you can ensure, our guarantee is that we will ensure that all of your clients are fully ERISA compliant with our ERISA wrap plan administration and compliance. Which that leads to the last award of the evening. And this one, as the last award, we will not make a mistake, because at the end of the day, who is the most important in all of this, right? It's your client. And so the award for the best picture, at the end of the day, we want that picture to be a very happy picture, a very good picture, a very thoughtful picture. We want your client to be able to create more dependency on you. And through ERISA, talking about ERISA, delivering on ERISA solutions can greatly enhance your relationship with your client. So we award the best picture to your client. All right, lastly, we want to thank you for attending. Unsure, I know there were several questions that were unanswered. If we were unable to answer your questions today, we will get with Ann and team, and we will be able to get a response back to you as quickly as we can. We thank you for your attendance and your participation in this webinar. Your questions actually enable us to provide even a better quality service than we have before. And so we appreciate the support that you've given us, and we are looking forward to really enabling our team to drive more business through your agency as well. So Seek, if you need to, you don't know how to get in touch with us, you can go directly to the phone numbers through Broker Concierge there in the corner, through phone, through email, through our LinkedIn. Please feel free to reach out to us. And for those of you that are wondering about the slide deck and the recording, we're providing everyone as follows. follow-up, a link to the recording. Everyone will receive some basic ERISA compliance services flyers that I think will enable you out as you're out with sales efforts and so forth. But for those in our who are our broker concierge partners, you have access to our broker portal, and the slide deck will be there, and all ERISA content and information that we've published. You have access to it all.